Hello, and welcome to In the Privy Council, a podcast reviewing cases heard before the Judicial Committee of His Majesty's Most Honourable Privy Council, brought to you by the Legal Style Blog. I'm your host, Elijah Granite. This week, we are discussing the Mauritian case of Galea and Assessment Review Committee, the citation for which is 2025 UKPC 17, Mauritius. And a reminder, because Mauritius is a republic, this case is decided directly by the Judicial Committee rather than by His Majesty. This case concerns a simple question. What does it mean to carry out an undertaking with a view to profit? Is an undertaking with no chance of making a profit still considered to be done with a view to profit if the person doing it really wants to make a profit and intends to, and therefore a business for the purposes of tax law? The facts are colorful. Mr. Galea is the principal owner of a partnership called Société Agricole de Mont-sur-Mont, abbreviated to SAM. The principal activity of this partnership is to, on land owned on Baie du Cap, on the island's southeast, run a little gentlemanly hunting activities known as chasse, with the deer Sam stalked the land with. And for these chasse, they charge a fee that if you bring your hunting dogs, you get in free. And by all accounts, a jolly sporting time is had. As an even more colorful aside, among other activities designed ostensibly to boost income over the years, Sam apparently also once sold live monkeys, but stopped because these sales were subsequently banned in Mauritius. This podcast doesn't dispense legal advice, but as life advice, don't buy a monkey, even if it's legal. It's not going to end well for you or the monkey. In any event, Sam's chasses lost quite a bit of money, since running a little lodge and maintaining land and deer entails staffing costs, and the hunts are much smaller and less expensive to enter, and indeed free if you bring your hunting dogs, than more identifiably commercial ones in Mauritius. Since this is a pass-through société, which for these purposes I'm calling a partnership, meaning the partners, which is a stand-in for the Mauritian term here, associé, bear their own losses rather than it being attributed to the corporate person of the société, that is, partnership. Mr. Galea ultimately deducted Sam's losses on his own personal income taxes, which aroused the wrath of the revenue and eventually led the case to go before an administrative tribunal, the Assessment Review Committee, that's ARC. The revenue's issue with Mr. Galea's deductions for Sam's losses was that this chasse was a little hobby for Mr. Galea, running a hunting club, but there was no reasonable way to expect any profit from it. No businessman would possibly keep running a business, quote-unquote, incurring such considerable losses. It was the revenues and the ARC's view, backed on appeal by the Supreme Court of Mauritius, that it was impossible to seriously contend that the activities in question were carried with a view to profit. Since the tax laws do not provide deductions for enjoying hunting fun, Mr. Galea had to pay up. At this point, let's take a look at the law. In this case, the applicable statute is the Income Tax Act 1995, which says in Section 2 that a business includes any activity earning income carried, quote, with a view to a profit. This statutory definition is common throughout the Commonwealth, so to understand it, we can look to authorities outside Mauritius. The most prominent case is from New Zealand, Grieve and Commissioner of Inland Revenue, 1984, 1 New Zealand Law Reports, page 101, Court of Appeal, where my lord, Justice Richardson, held that the only relevant question in determining if there was a view to a profit was entirely a subjective one. That means that even a business with absolutely no realistic chance of ever turning a profit could still count for tax purposes as a business if there was a genuine intention to make a profit, even if all the facts suggested this was, frankly, a delusional intention. To quote Justice Richardson at page 110, businesses do not cease to be businesses because they are carried on idiosyncratically, or inefficiently, or unprofitably, or because the taxpayer derives personal satisfaction from the venture. In other words, bonfires of money in service of a hobby can still count if there is a genuine intention to make a profit. Board, my lady. Dame Philippa Whipple, DBE, normally found on the English Court of Appeal, held that this test put in question as erroneous the decision of the ARC, since it relied on an objective conclusion from the evident circumstances, that objective conclusion being that this could not possibly be a venture with a view to a profit, since Sam was a bonfire of money. Indeed, the only conclusion given the test set out in Grieve and other case law was that there was a manifest error of law here, and therefore ARC's decision set aside. The board then considered if the decision needed to be remade on fresh analysis. That is to say, having set aside the decision of ARC, if the consequence should now be a finding in favor of Mr. Galea's deductions. Mr. Galea's counsel pointed that there were investments in the land for Sam, attempts to generate income, including by the sale of monkeys, and a reduction in the scale of the losses in recent years in the relevant period, though it was certainly still a money-losing venture. The ARC's counsel, by contrast, tried to argue Mr. Galea's evidence at first instance was lacking credibility, that when he stated his subjective intent to form a profit, he was lying or misleading the tribunal. However, Dame Philippa pointed out that the record showed there was no adverse finding below about his credibility, and a witness cannot be impugned only on a second appeal. In any case, various side ventures, including the attempt to sell monkeys, and once again, I implore you, my dear listeners, don't buy or sell monkeys, please. And various other evidence showed plans to generate income. However, harebrained, or perhaps monkey-brained, those schemes were, and this record bolstered Mr. Galea's credibility, which in any case had not been found to be lacking below. As a result, the board remade the decision in Mr. Galea's favor, and his deductions are allowed. This is a short and sweet case with 3 interesting points. First, it shows the majesty of a truly subjective test in law. However delusional an entrepreneur may be, an income-generating activity where there is a genuine intent to make a profit is a business for the purposes of tax. This is true even where the main purpose of an activity seems to be a hobby, as long as the profit intent is some part of it. The price for being a delusionally bad businessman is the literal price of losing your money, not tax sanctions. Second, there's an interesting behind-the-scenes wrinkle. This case was quite short, but as my lady, Dame Philippa, notes, that was only because very late in the appeal, the ARC's counsel finally acknowledged and stipulated that the applicable test from the case law led by Grieve was purely subjective, leaving the counsel with only a few wild arguments. This concession is a credit to to ARC's counsel before the board, Mr. Philip Baker, KC. The duty towards the tribunal requires that a lawyer not advance a legally untenable argument. When the case came to Mr. Baker, KC, he rightly abandoned the previous attempt to argue for an objective test because the settled Commonwealth case law was very clear it was a subjective test. This made Mr. Baker, KC's job rather difficult, but it was the proper thing to do. A lawyer must argue zealously for her client, but that does not mean arguing contra legem, and there's an ethical obligation to do exactly as Mr. Baker, KC did here when an appeal comes to one, and the arguments below are clearly not legally tenable. Finally, this case does not speak well about the delays in the Mauritian system of justice. Mr. Galea was first investigated by the Revenue beginning in 2007. The ARC finally decided the case in 2013. Mr. Galea filed his appeal with the Supreme Court in 2016 and did not get a decision there until 2023. It is, of course, now 2025. Justice delayed is justice denied, and it is very bad that it has taken for 12 years for the review of an administrative tribunal's decision over taxes themselves from 6 years prior to finally come to an end. Thank you very much for listening to another episode of In the Privy Council, brought to you by the Legal Style blog. I've been your host, Elijah Granite. If you want more legal content, visit our website, legalstyle.co.uk, or follow us on Twitter @LegalStyleBlog. If you have any comments, suggestions, rants, or raves, the email of the podcast is editor@legalstyle.co.uk. We also welcome any ratings or reviews on your usual podcast platforms. Until next time, goodbye, and remember, God save the King, and gloire à toi, Île Maurice.